And Ms. Coulters, why haven't we had a gun board letter submitted as of today?
Your Honor, I was recently assigned to this case as House Counsel, and I am still awaiting receipt of documents my relatively new client needs to forward to me. And so I've been awaiting receipt of some documentation he wishes to share with the gun board.
Well, your client, Mr. Fuller, failed to appear for a calendar conference back on November 25th. When were you appointed?
Your Honor, I was appointed on, let's see, what day was this? The 5th of last month. And he was in custody. He was released. I forget the date on which he was released. Oh yeah, it was the 5th, I think.
Well, what I'll do, I'm going to give you one adjournment here. We'll do it on March 22nd. We'll adjourn this to March 22nd. You need to get that gun board letter in ASAP. This case has been hanging around way too long to be waiting for a calendar conference. But Ms. Coulters, because you're new to the case, relatively speaking, it's been a month. I'm going to give you that opportunity, but you need to be working with your client to get that gun board letter in. You know better than the court does how backed up that gun board is, and you've heard Ms. Maddox already say that 2 weeks may not be enough time, so that needs to get in sooner rather than later. All right.
Absolutely, Your Honor. I will step on it.
All right. Anything further?
Ms. Carthers, when you submit your gun board letter, can you CC me?
Absolutely. Absolutely. I'll make note of that.
Okay.
Thank you.
March 22nd at the request of the defense.
And I guess just for the record, there was an offer. And if the people can place the offer on the record, at least Mr. Fuller will know what might await him as regards to an offer, assuming our first.
The offer mechanics.
I'm sorry, I didn't hear you.
The offer, Ms. Maddox.
I do not have this file yet. As I said earlier, the transition has not been very smooth with the judges, you and Mr. Edwards, or Judge Edwards, switching courtrooms. So I have been on a hunt to try to find files because they're still marking them as Thomas Hathaway and going to a different attorney. So I have to find it.
Your Honor, I did receive an email from APA Maddox, and if I may, I could read the people's settlement offer.
That was for, I thought that was for your other client, Mr. Robinson.
William, let's see. Disregard that, Your Honor. I'm thinking of my other client.
Very good. All right.
March 22nd.
March 22nd, 9 a.m.
Thank you very much, Your Honor.
I'm going to have you back here March 22nd. Any questions?
Nothing from the defense. Thank you. I'll be speaking to you, Mr. Fuller. Please get me the documents.
Judge, Ms. Sprinkle has Keith Williams, who's supposed to have a diversion. He was accepted, but I don't know if you all have the diversion form. I don't have it.
I don't have it.
All right, well, I'll call the case, Your Honor.
Let's do it, and Ms. Maddox may get it.
Okay. For the record, calling People versus Keith Leroy Williams. This is case 21-43201FH. This is the date and time scheduled for an arraignment on the information. Appearances, please.
Brittany Maddox on behalf of the people, P83204.
Good afternoon.
Good morning, Your Honor. May it please the court, Carolina Sprinkle, P49898, appearing on behalf of Mr. Keith Williams II. Mr. Williams has agreed to have this matter heard via Zoom, and he is on Zoom, Your Honor.
Very good. And Mr. Williams, please introduce yourself. Full name? Mr. Williams, are you here?
Is Mr. Williams not?
I'm just calling to make sure, coming in here to make sure everything is okay. Is everything good with this defendant so you can go to the next one?
Mr. Williams, I don't think he's there.
Okay, well, we'll have to come back to that. I thought they were ready.
Ready on William Johnson.
All right, but Mr. Jadala's next. Sorry.
Did we pass Williams?
Well, we don't see Mr. Williams.
Okay, I'll see if I can text him. Thank you. He was here.
All right, well, as soon as you come back, we'll get to your case. Are you ready, Mr. Jadala?
Yes, Judge. Yeah.
Ready, Judge?
Yeah, I'm having difficulty with my screen here.
Oh,
Something YouTube.
you can minimize that thing?
No.
Oh, there we go.
See, that's not, but that's still not it. Let's see, this is YouTube.
Are we supposed to be recording on YouTube?
Yep.
Okay.
Just one moment.
Okay. Let me take this to Kathy and let her know if he probably needs a writ or something.
All right. I'm gonna be, hold on, everybody. I've got a problem with my screen. I hope I don't disconnect the YouTube Zoom, or the courtroom Zoom. If I do, I'll set it right back up again. Okay, we're good.
Okay, we're good? All
Yep.
right. For the record, calling People versus Dylan Schufert. This is case 21-50001FH. This matter before the court is a calendar conference. Appearances, please.
Brittany Maddox on behalf of the people, P83204.
And respectfully, Your Honor, Samer Jadala, P62186, appearing on behalf of Mr. Schufert, who also joins us via Zoom with no objections joining via that forum. Mr. Schufert, would you say your name, please?
Dylan Schufert.
Mr. Schubert, good morning to you.
Good morning, you too, Your Honor.
All right, and again, I appreciate the fact that you've come dressed appropriately for the decorum of this Zoom courtroom proceeding, sir. Thank you.
You're more than welcome, Your Honor.
And Mr. Schufert, we're here for the disposition conference. Where do we stand?
Your Honor, a gun board letter has been submitted, Your Honor. Ms. Maddox has informed me that it has not, as of yet, been responded to. I would ask if this court would adjourn to the 17th. Hopefully that gives the gun board enough time for us to return with an offer, Judge.
I think that's a good idea. The 17th, we can do that. That'll be Wednesday, the March 17th at 9 o'clock then. Mr. Schufert, you're going to be back in the same Zoom courtroom. All right.
Yes. All right.
And hopefully we will have that result from the gun board. Very
Thank you,
good.
Judge.
Okay.
Thank you. Further on the Schufert matter.
No, Your Honor.
You and your staff have a wonderful day, Judge.
Thank you.
I think they're having a hard time too, trying to get things done.
Good morning, Your Honor. This is APA Alex Trinahachi. I'm checking in on Bryce Dooley. I don't see either defendant or counsel. I believe it's Ed Taylor.
Julie,
Mr. Korohachi, can I get your P number, please?
Sure, 81844.
Julie is not, oh yeah, there
Oh,
you
there
go.
he is.
Yeah,
So,
calendar conference. You might want to get
and
a
that's
hold
what
of
Ed
Mr.
Taylor, who I haven't seen today.
Yes. Oh, Mr. Taylor. Let's see if we can't get his,
492. I just wrote his P number down because I can't hear it. No, 81844. Cold-Thirst had another case. What was your other case, Ms. Cold-Thirst? I forgot.
My other case is William Johnson. He's using his wife's device and the name should read Renee McLean.
Here, Judge, she did tell me that earlier. There you go.
Okay.
That's the device he's using.
I don't see McLean here. No, McLean is not here.
Ms. Sprinkle, did you ever get in touch? Is your client here yet? No, I guess not. Who is that sitting there?
That's Mr. Searcy.
Oh, that's Mr. Searcy? Okay.
Yeah, and Madam Clerk, we are ready, Michael Desi, with Mr. Searcy and then the prosecutor, APA Thomas Chambers. We are all on and ready.
Let me find this file right quick.
Okay, that's the one that was added.
Oh, the 04 case.
That's right.
All right, let me pull it up from here because I don't think I have the file, Judge, do you?
No, it's, I think the file is Court of Appeals.
Oh, okay. Okay. Well, if you need anything from that file, I'm gonna call the case as soon as I locate where I put it. There it is. Okay, we're on the record with the matter of People versus Thelonious Searcy, case 04-1289001 FC. This matter before the court is a motion hearing. Attorney appearances, please.
Good morning, Your Honor. On behalf of the defendant, Sean Searcy, this is Michael Desi, P 64530.
Mr. Desi, good morning.
Good morning.
Good morning, Your Honor. Thomas Chambers, Assistant Prosecuting Attorney, appearing on behalf of the people. My P number is 32662.
And Mr. Chambers, good morning to you. And
Morning,
Mr.
Your Honor.
Searcy, please introduce yourself with your full name. You're muted. Please introduce yourself with your full name. Still muted.
You might need some about it and then try to unmute it. Try it.
No, you're still muted here. Oh, wait a minute. Let me just check. No?
Maybe he's trying to give us a note. Can you see it? Because I can't.
Can't read it. Let's see.
Okay. Okay, that's good.
Green cat American.
All right, and
on your end.
be mute on your. It says you must be muted on this end.
It looks like he's unmuted now.
Can you hear us? Hello? Hello?
Yeah.
Yes, now we can. Very good. And Mr. Searcy, please introduce yourself.
Thelonious Sean Searcy.
All right, Mr. Searcy, good morning to you.
Good morning, Judge.
All right, and we're proceeding with your hearing today with remote Zoom technology. Do you consent to this process?
Yes, sir.
All right, very good. Then, Mr. Desi, this is your motion. You may proceed when you're ready.
Yes, thank you, Your Honor. Again, Michael Desi. Your Honor, I know that you're new to this case. It's an 04 case, as your clerk and you had pointed out. My client has been incarcerated for almost 17 years, and we recently received an opinion from the Court of Appeals, which granted my client a new trial after there was newly discovered evidence in the form of a confession that had come from Vincent Smothers, confessing to the crime for which my client was convicted. Your Honor, my client has maintained his innocence for all of these 17 years, And the Court of Appeals wrote a very detailed and lengthy opinion in which they found that not only is Mr. Searcy entitled to a new trial, but they also actually pointed out and said that they believe he's reasonably likely to be acquitted if he were to be retried. And Your Honor, there were many details and factual details that went into the Court of Appeals opinion, but I want to highlight one of them, which is most important. Aside from the fact that there was a confession from another man who confessed to the crime, but there was forensic evidence that was withheld from the defense at the time of trial. And that forensic evidence is absolutely exculpatory to my client. So this case comes to you in a little bit of a procedural anomaly, because usually a defendant is seeking an appellate bond after a conviction, but before there's a direct appeal. And in this instance, we're coming to you asking for a bond because of the Court of Appeals opinion, but also because, you know, the case might proceed at the appellate level for some time. I did reach out to my brother counsel and asked if we could discuss the case or how to move forward. And I understand that they indicated they might be filing an appeal to the Supreme Court. But in any event, it is my position that my client should be granted a bond pending further proceedings in this case, which the case could linger for quite some time, especially with COVID and the case is moving more slowly in the Court of Appeals. Your Honor, I looked back at my client's pre-sentence report. He had 0 convictions. He had 0 felony and 0 misdemeanor convictions before he came to this court in 2004. He has 0 convictions while he's been incarcerated. He's had 0 misconduct tickets for a period of at least 7 years while he's been incarcerated in MDOC. Your Honor, I could go on and give you a whole list of accomplishments and accolades about my client. He successfully completed the Blackstone paralegal program. He has been intimately active in helping me and assisting me with his case and his defense. He has successfully completed a number of courses while in MDOC, all of which speak to both his character and the fact that he doesn't present any danger to the community. Now, the prosecution filed a response and, they said he's dangerous and we think he did this and we think he did that and he assaulted somebody. Again, Your Honor, he has 0 convictions. He came to this court with 0 convictions and he has no convictions other than this instant case, for which the Court of Appeals said he's reasonably likely to be acquitted in light of this new evidence, some of which was apparently withheld from the defense, which was exculpatory. Your Honor, beyond those positive attributes, Mr. Searcy has family in the community. He has 2 daughters, aged 23 and 24, with grandchildren. His grandmother, who has stood by his side for 17 years and has been helping him and assisting him in these proceedings and seeking his freedom and seeking to overturn this conviction. And his family is all very supportive and they're all in the community, and he intends to reside with his grandmother in Roseville if Your Honor sees fit to grant him an appellate bond. And that is what we're asking you to do today. I know that there's a lot of information in there. If you have other questions for me, I'm happy to answer those. Otherwise, the remainder of my arguments I set forth in my emergency motion for bond, which was filed with Your Honor last week.
Well, Mr. Desi, you do indicate that this matter comes to this court in an unusual appellate position. You have been, your client was the recipient of the Court of Appeals decision that came down just last week, I guess it was, right?
It was a couple of weeks ago, Your Honor. It was
February 11th, and you're seeking appellate bond. Also court rule for pretrial release, which is the regular court rule, MCR 601C, pretrial release. What specifically, are you going under the statute? Are you going under the court rule? Both? What?
Under the statute, Your Honor. And actually, the prosecutor filed his response this morning, and I understand they agreed that the statute is the correct basis. I put the court rule in there only because of, again, the unusual circumstances of how this presents itself to you. But the MCL 770.9 is the statute, which it appears that both the prosecutor's office and I agree on is the appropriate statute for consideration. And the court rules for the Court of Appeals court rules requires that we first move for a bond before Your Honor. So it's not that we would move in the Court of Appeals for the bond. We have to first seek the bond from Your Honor. And we would do that under 770.9A. I just cited the court rule just as an example of what some of the factors are to be considered. But it appears that from reading the prosecutor's brief, the major factor that we're disputing is whether my client is a danger. And that's the factor that they've noted as well as I've noted under MCL 770.9A. And for all the reasons that I've pointed out, I'm asking Your Honor to make a finding that he's not a danger, given that he has no criminal record either before or since this conviction. And in light of the fact that we did prevail at the Court of Appeals and that they found that he is likely to be acquitted. And, you know, Your Honor, I don't probably need to tell you this, but the Court of Appeals doesn't say things. They don't go out of their way to make statements like that very often in these types of findings on these 6500 motions.
Mm-hmm. Well, you do raise the issue about under the statute. There are two determinations because your client was convicted of an assaultive crime. So I do find that MCL 770.9A and 9A2 is applicable here. And that statute does say that if an individual is convicted of an assaultive crime, that person shall be detained and not admitted to bail unless the court finds by clear and convincing evidence that Section 9B of the chapter does not apply and that both of the following do exist. A, the defendant is not likely to pose a danger to other persons, and B, the appeal or application raises substantial questions of law or fact. Now, I do see from the prosecution, they don't dispute sub B. They do acknowledge that the application for this court coming from the Court of Appeals decision, clearly there is a substantial question of law or fact. The court determined unanimously that the matter should be remanded for a new trial. But where the people opposed your motion is on the basis that your client is likely to pose a danger to other persons. And in their brief, they cite several circumstances, including allegations with regard to a Mr. Witcher. That's a D. Anthony Witcher, W-I-T-C-H-E-R, which goes through a series of, shall we say, interesting assaultive allegations with the claim that there was a gunshot wounds from your client to Mr. Witcher, also damage to a home, and then threats of, quote, "I got to kill you," close quote. But you're telling me that prior to this conviction back in 2005, your client had no convictions for felonies or misdemeanors. So in other words, Mr. Witcher never became a victim in a criminal action against your client?
That's correct, Your Honor. And again, I pulled out my client's pre-sentence report this morning to make sure of these facts. But the incident, which is what you just referred to and talked about with this Mr. DeWitcher, my client was never charged with any crime from that incident. So it's simply just unfounded allegations that were raised and asserted based on whatever was some apparent neighborhood argument or dispute, of which we don't know, but my client was never charged with that. He was charged in a different case against a Witcher, Harvey Witcher, and that case was dismissed. So there are no allegations that have been substantiated, and the prosecution can't substantiate those because there are no charges relating to those cases, and there's no convictions related to those incidences that they raise. So I believe it's just mere, allegations that they're asking the court to accept to overcome a presumption of the fact that we believe he's entitled to be presumed innocent at this point. And I agree with Your Honor that, we are disputing the one factor under the statute, which is the dangerousness. And that is the dispute between the parties. And given the absence of his record and given his accomplishments in MDOC over all of these years, I'm asking the court to make the finding that he would not present any danger to the community. and should be bonded out at least pending further proceedings, which we don't know how long those proceedings will continue.
All right. Well, then let me ask this question then. This matter is going to be remanded to this court for a trial unless the prosecution appeals successfully and the Court of Appeals decision is overturned. But let's fast forward to it's remanded to this court. At that point in time, your client is going to be standing trial for the same charges that he was previously convicted of, correct?
That would be correct, Your Honor. I would assume that would be correct.
And at that time, back in 2004, 2005, your client was remanded into jail custody and was held without bond, correct?
Well, he was,
Oh, sorry.
I believe he actually, there was a bond that was issued. However, the amount of the bond made it cost prohibitive for my client to post that, but he was bonded. He just couldn't make the bond as far as I understand. And that I believe that is reflected in the PSR that I have in front of me. I believe he was bonded out, Your Honor. He didn't make the bond, but it wasn't that there was a finding that they denied the bond. The bond was just, the cost was too high.
Okay, because I looked at the Register of Actions this morning and all I saw was remand, but you're saying that there was a bond that was granted?
That's correct, Your Honor. My understanding is there was a bond that was granted, but it's just that it was cost prohibitive and he couldn't post it. But it wasn't that he was denied a bond to stay in custody. He was given a bond that he just couldn't make, given the amount of money.
All right. Then Mr. Chambers, what's your response here?
Well, I see that you read my response, and I'm sorry it was not filed Friday, but I'm a part-time employee here on a contract, and I used to get emails at home. I worked till noon on Thursday, and I didn't get the emails between Mr. Desi and your law clerk that were exchanged after Thursday. You know, after I had left work and I wasn't in on Friday, and I used to get emails at home, and then that discontinued after the first of the year. And I've asked the county to try and remedy that a number of times, and I've heard nothing. So that's why when I came in this morning, I was surprised to see that it was up today, and I immediately filed a response. And I just wanted to explain why I didn't, respond Friday and why I responded this morning. But
I appreciate that, and I got to tell you, I'm impressed that you came up with such a lengthy reply in such a short period of time. But it was very, very helpful for the court. So,
thank you, Your Honor. I just
you.
wanted to also point out that the defendant's own witness, Vincent Smothers, had indicated to the investigator, Scott Lewis, he indicated that he knew of the defendant's reputation. At the evidentiary hearing in this case, I asked Smothers, what is his reputation? And Smothers said his reputation was he's a robber. Now, this comes from the defendant's own witness, Vincent Smothers. And then finally, Your Honor, the fact remains that when the police went to his grandmother's house to arrest him, he was hiding in the upstairs closet. And in that same room was a gun that was connected to casings that were fired at the scene, one of which was near the vehicle of the victim.
All right, but did Mr. Smothers also indicate that as part of his confession, that he and Mr. Daniel were the two that actually were the shooters in the case in which Mr. Searcy was convicted, and that Mr. Smothers gave both his .40 caliber weapon to Mr. Daniel, who had a .45 caliber weapon at that evening, according to Mr. Smothers' confession. And he told Daniel to get rid of both of them. And didn't Mr. Searcy's grandmother indicate that the gun was not Mr. Searcy's when the police came and got it, but rather that a Mr. Daniel had dropped it off previously? Now, isn't that all true also from Mr. Smothers?
Yes, that is true. And what is also true is that the defendant's grandmother testified that testified at the original hearing that Daniels dropped that gun off in August of 2004. And this incident occurred in September of 2004. I guess it was 2004. So how is it that the grandmother has the gun on August 2004 and it's used a month later at the scene? How does that make sense?
All right, but let me just pose this then. Let's assume that Mr. Searcy did have that weapon and he was at the scene at that evening and fired the 45 caliber weapon, but it was a 40 caliber weapon that killed the decedent, correct?
Correct.
So that would mean that Mr. Searcy would not be the person who was the actual murderer, correct?
That's assuming that Searcy was at the scene and that he was the one shooting the 45 caliber handgun. But there were four eyewitnesses three of whom identified the defendant by face as the shooter.
Right, right. And there are other witnesses that gave alibi testimony that he wasn't at that event on that evening, correct?
That's correct.
All right. Well, but the bullets that were found to have come from the body of the deceased were 40 caliber, not 45 caliber, correct?
Correct.
So even if the gun was at the house and even if the gun was used by Mr. Searcy, he would not have been the one who killed the decedent, correct?
If he was the one that had the 45 caliber, except that one of those 45 caliber casings were in the vicinity, were in close proximity to the other 40 calibers at the, in the vicinity of the victim's vehicle.
Right.
And again, there were eyewitnesses that said that Searcy was the shooter. And they picked, and two of these three people picked him out of a photo show up.
I know.
So just because
we've got conflicting facts here, and that sounds like what? Reasonable doubt, question of fact, right?
Correct, but the question is, the question still is, does he pose a reasonable danger to people now?
Right, and that is the key question. Does he pose a threat today? In 2004, there's no evidence of previous felony or misdemeanor convictions. There's a reputation for being a robber. Now that's a statement. Somebody who's heard it from other people. He knew him by reputation. Who knows how accurate the reputation was? I'm not going to engage in speculation on that, but what I'm looking at is that there is no record of convictions. I did hear just recently from Mr. Desi that he was charged with a crime and it was dismissed. Certainly, the fact that there's a weapon in the vicinity of where your defendant, Mr. Searcy, was arrested raises troubling questions. The fact that it was a weapon that was tied by its caliber and the shells to the events at the murder raises further questions. But there is also the fact of the confession, the fact of alibi witnesses, and I think as I look at the Court of Appeals opinion, what it says here is, I'm quoting from the last full paragraph, although the jury disregarded the many witnesses who provided alibi testimony on behalf of Searcy at trial, if the jury was aware that the bullet that was found in the murder victim was from a 40 caliber gun and that Smothers was taking responsibility for the crimes, they may have put more stock in Searcy's alibi defense. As already stated, when, quote, the verdict is already of questionable validity, additional evidence of relatively minor importance might be sufficient to create a reasonable doubt, close quote, citing the Johnson case. And then the court continues, at retrial, we conclude that Searcy has a reasonable likely chance of acquittal. Therefore, the trial court abused its discretion by denying Searcy's motion for relief from judgment with respect to his claim of new evidence relating to Smothers, and it cites the Smothers confession. But as this court is required to do in determining this motion, I have to have facts that show that Mr. Searcy today poses a threat to the community. And if his record is as stated, no felony, no misdemeanors beforehand, and he has a record for the last 7 years in the Michigan Department of Corrections without any write-ups, without any misconducts. I've also heard that he's taken Blackstone paralegal training, has been involved in other things. It does seem to this court that currently, I don't have any evidence that Mr. Searcy does pose an immediate threat to the public or to any individuals. And again, I do note that at retrial, if that is what happens here, Mr. Searcy may run into problems with the eyewitness testimony again, but I do think that at the original trial, without the ballistics evidence of the .40 caliber bullets in the body of the deceased, and without the confession testimony of Mr. Smothers, he didn't have the same fair trial that would be available to him now. And I think that that was what the Court of Appeals stated. Considering the trial evidence in light of the other evidence that would be presented at retrial. So I do think under the statute, MCL 770.9A, it does pertain to this motion, and the requirement is for this court to find by clear and convincing evidence that the defendant is not likely to pose a danger to other persons. I have seen or received no evidence at this point from the prosecution or the defense that this defendant today in 2021 poses a danger to other persons. I do find that the appeal application at issue here does raise substantial questions of law or fact, and I do find by clear and convincing evidence that the defendant and Mr. Searcy is not likely to pose a danger to other persons based upon the record that I have received and have available to me today. I therefore am going to grant the motion for bond pending the appeal. And I do note, Mr. Chambers, that you indicate that the people are anticipating filing an application for leave to appeal to the Michigan Supreme Court. Is that accurate or not?
That's accurate, Your Honor.
All right. And what is the time frame for doing that?
We have till April 4th, I believe. It's 56 days from the Court of Appeals opinion, which was February 11th.
Okay, what I'm going to do, I'm going to issue an order granting the appeal bond, and I'm going to specify the terms and conditions of it. But I'm going to stay that effective date until April 4th. If you file that application within that time frame, you can come back to the court. At that point, we can address the issue again, or you can make an application to the appellate court for visiting my decision here.
Yes, Your Honor.
Okay, and what I'm going to do, I'm going to, boy, I hate to do this because I don't have the information as to what that bond was that was originally posted. that was originally ordered, but not. Do we have any way of finding that out?
No, Your Honor, I looked on the register. It's not on the register.
No, that's what I looked too. I couldn't find it. I was trying to determine that.
Usually they will change my conviction of a cap case.
Right, but he was remanded originally on warrant. And then I didn't see anything else after that in the ROA. So I assumed he was remanded the entire time, but we've just learned that there was a bond, but he couldn't make it. And we don't have the file, as I say, it's in the appellate court, so I don't have access to any facts other than what these two motions have brought us, looking at the ROA.
Right, it's not that much on the ROA, but I'm gonna ask my supervisor, is there any way we can get more information
Right.
about this case?
And Mr. Desi, do you have any way of finding out that information?
Your Honor, I don't have the actual documentation in front of me. I was looking for it myself. I know my client had mentioned an amount, but to be honest, I'm not certain. I don't want to guess. But I did look and I wasn't able to find it.
Okay, well, I'm going to do the interim then, and I want you to prepare this order for my review and signature, get it approved as to form by the prosecution. It would be, at this point, it would be a bond for house arrest with a GPS tether, no out times. He is going to be required, your client, Mr. Searcy, is required to not leave the state, not leave the house. He is to appear at all court functions. We can do it by Zoom for the near term, and we'll determine things afterwards. There's to be no use of other intoxicating substances. I assume he does not have a driver's license, but there's going to be no driving. He is not to possess or use a firearm. He is not to have over at the house, and as you indicated in the pleadings, he is going to be staying with his grandmother, correct?
That's correct, Your Honor.
All right. There has to be a validated, verified address, and what is that address?
Your Honor, I'm not sure that I have that address off. I'm not sure that I have that address offhand, Your Honor.
Well, it needs to be in the order.
Sure.
Because that's going to be the house arrest location. Right? And again, he's not to be in contact with anybody at that location who he knows has controlled substances or weapons.
I'm waiting for his order to be sent, but
That's right. That's right. Any questions?
Your Honor, I was not entirely clear what you said about the stay or how the order was going to take effect.
Well, I'm issuing the order, but I'm staying the order until April 4th, which is the 56th day upon which the prosecution can file that application for leave to appeal. All right. If the prosecution files that application by April 4th, I'm directing the prosecution to address their appeal, if you will, or contest of this order to the appellate court, if that's the appropriate body to do so. But I'm staying this order until either the appeal application is filed or April 4th, whichever comes first. All right.
All right.
I'm going to give the prosecution that opportunity to do that. And I would assume that when they file their application, they'll also be challenging the issuance of this bond.
All right. I understood, Your Honor. Thank you for clarifying that.
Okay. And Mr. Chambers, is that accurate, or am I putting thoughts and words into the prosecution's mind?
I guess is your order granting, well, first of all, is there a cash amount on the bond?
No, it's going to be house arrest with GPS tether. I don't know what I don't know what the bond amount was, so I can't give that. I don't have a pretrial services report, so I don't have that information. So at this point, what I'm going to do, given the detailed analysis by the Court of Appeals, and given what is likely to be the testimony in part at the new trial, which does raise all kinds of questions about potential reasonable doubt for any jury to again convict this defendant of the same crimes he was convicted of back in 2005. I don't have a cash amount that I can put on that at this point.
But
And I've received input from either you or the defense. And I've sought it, but we don't have it. So at this point, it's going to be house arrest. And that certainly, it can be challenged when we come back here. If there's any violations of that court order, we can address it at that time. But I'm going to place bond at this point based upon what I see. And I again quote what the Court of Appeals states. At retrial, we conclude that Searcy has a reasonably likely chance of acquittal. That doesn't mean he's going to be acquitted, but there's that chance of that. And given what I've seen here from the facts that were adduced at that appellate level, facts that never were introduced at the trial level, I certainly don't dispute what the appellate panel was saying. So I think house arrest at this time is the most appropriate thing we could do.
okay, but are you staying that until April 4th?
Or until you file your application.
Okay, at which point, if we file our application, that's when it goes, the house arrest goes into effect?
That's right. And at that point, you can challenge my determination.
Okay, I got it.
I'm giving you time to do that is what I'm saying.
Right. Correct.
Okay.
Yes.
Okay.
Yeah, I appreciate that, Your Honor.
Okay. And Mr. Desi, anything further?
No, Your Honor, I understand the terms of your bond. Thank you. Your Honor, if I would just ask if I could be put back in a breakout room with my client before we get off of the Zoom, it would be most helpful.
All right. Very good. We will do that. And Mr. Searcy, I'm going to put you back in that breakout room with your attorney. And
We have a return date.
it's got to be remanded to us, so there's not much we can do. I don't do anything. We can just mark down April 4th as a review date.
Okay.
So we can see what, if anything, is occurred. All right.
April 4th happened, Your Honor.
Oh, then we'll do April 5th. All right, I'm going to put Mr. Desi, okay.
Thank you, Your Honor, and I appreciate you getting us on the calendar this morning. Thank you.
Very good. All right, counsel, thank you.
Thank you, Your Honor.
All right, Mr. Chambers, thank you. Appreciate it. You know what you should do here, Crystal, instead of appellate bond, motion of same is granted, written order to follow.
Okay.
Okay.
I can just change that, Judge, instead of having you sign.
Oh, okay.
Okay.
Good.
And I don't know if Ms. Sprinkle, is your client, Mr. Williams, here?
Yes, Mr. Williams was there the last time, but his audio wasn't working.
Okay. Okay, ready, Judge?
Yes.
All right, party on Williams, are you ready?
Yes.
Okay, for the record, calling case 21-43201FH, People versus Keith Williams.
All right.
Now, for the-
It's been a long morning. We are in the home stretch.
Appearances, please.
Brittany Maddox on behalf of the people, P83204.
Good morning, Your Honor. Caroletta Sprinkle, P49898 on behalf of Keith Williams II.
And good morning to you. And Mr. Williams, please introduce yourself. I think you're muted. You're still muted, Mr. Williams. There you go.
Hi, this is Keith Williams II.
And Mr. Williams, good morning to you.
Good morning.
And we're proceeding with your hearing today on Zoom. Do you consent?
Yes, Your Honor.
Very good. And where do we stand, counsel?
Your Honor, this matter is set for arraignment on the general information. As to the arraignment, I waive formal reading, stand my client mute. We did submit a gun board letter. Mr. Williams was granted diversion. I emailed Mr. Heafy for the diversion order to be emailed to the courtroom.
All right. Well, first things first, Mr. Williams, your attorney has stood you and waived the formal reading of the felony information charge. I'll enter a not guilty plea. That places your case down in the Third Circuit Court docket. And Ms. Maddox, can you enlighten us at all on the diversion motion by the people?
I have no information on the diversion application. Mr. Heafy did not email me an order.
And Ms. Sprinkle, you say you've got communication with Mr. Heafy that says he's been granting that?
Yes, I have an email from Mr. Heafy, which is dated quite some time ago. And I forwarded to my client. Let's see. That email was dated January 14th, Your Honor.
Maybe Kathy might have it. Or in her email or something.
Where's Kathy? Where is she?
Probably in her office. Let me see.
Yes. She's probably out here.
But I don't listen, that's the thing that you used to want. Judge?
Yes.
She said that there wasn't even you guys' case then, it was still Judge Edwards' case, so she might not even have that email.
Oh. Well, as you know, Ms. Sprinkle, Judge Edwards and I exchanged dockets. If you sent the email to the court back in January, that would have gone to Judge Edwards' law clerk, Keith Leroy Williams. So I don't know what we can do beyond saying that we should probably schedule this for a calendar conference. And at that time, hopefully you'll have some word on diversion.
No, I was granted diversion. I've known that I've been granted diversion since January 14th.
You just don't have the order.
Right.
Right. There's nothing I can do.
Okay, well.
So, I don't have either.
Okay, so right. Calendar conference date?
Yeah. Let's give you a calendar conference date that we can try to track this down. And Ms. Maddox, is this something that you can put on your to-do list?
Honestly, Your Honor, if Ms. Sprinkle can just email Mr. Heafy to have him send it, to send it to Kathleen. I don't really have time to do it. I apologize.
I've already sent that email when you mentioned it earlier. I checked my email. He didn't respond to me, so.
Okay, well, we'll just wait for the order from Mr. Heafy.
All right. Well, then we can Monday the 25th.
March 25th.
Yes.
Do you have that date, Mr. Williams, March 25th?
Yes, ma'am.
All right. Thank you so much, Your Honor.
Time out. I can't. I don't have a docket that day. Let's do March 15th.
That's even better. Thank you.
All right. Very good. All right. That's why I had a few things there.
Have a great day.
You too, even on days
Thank
that I don't have case, I get cases.
Oh, yeah, they always put arraignments on docket law.
I'm supposed to. Out of here.
Okay, our party's ready on, Johnson, William Johnson?
Yes, we are.
Okay, is that Mr. Johnson?
Yes, it is. William, Mr. Johnson?
Yes, yes, ma'am. I'm here.
They've scheduled me for an ER docket on my vacation day. April 9th. I mean, we don't have to do that. I mean,
And whoever kids are in school, put your phone on mute.
I'm sorry? Okay, that's fine. We're on the
That's
record
Mr.
right
William
now.
Johnson.
All right, fine. I'm sorry, Judge, I was an attorney who thought, went to the wrong docket. He went to Judge, Prentice Edwards.
Well, then he should. That's me.
Oh,
I have Judge Edwards docket.
but I thought it was under you now.
It is.
Okay. He said-
But see, people still think it's Judge Edwards. I mean, I don't know. I assume, I don't know. I can't speak for him, but
He didn't know that the docket was switched at all.
there you go. Yeah,
He didn't
I
know.
think a lot of people are discovering that because not much was said about it.
Not much. I didn't know where to go.
And see that, like, I'm telling you right now,
Right. Right, that's age is non-cap. Okay.
Mr. Kearney, what case are you here on?
Mr. Copley?
What, okay?
He is in custody. So is that on my in custody docket? I think that's at the 1 o'clock docket.
Yeah, I think it is too.
You know what? But he's not on that.
He's not on that docket.
No.
And he's on a calendar conference on your day docket, but he's in custody. So
Right.
how is that gonna happen? Maybe they're gonna bring him this afternoon, I don't know.
Yeah. It'll be at 1 o'clock, Mr. Kearney, if we're able to do it. He is in custody. Let me just take a look here. And I see also that there's a Mr. Davis who's in custody that is not on my in custody docket, but he's here on my additional matters docket. No. Well, Mr. Kearney, let me ask you this. Is there any change in status with Mr. Copley?
Yeah, the prosecution did offer an additional plea offer in the case, and the other reason it was set for today was for a Cobb's evaluation.
Okay. Did you submit a Cobb's evaluation memo?
I did.
And when did you do that?
Thursday, Judge.
Thursday?
Yes.
Did you do it to my court email or my regular email?
I filed it through the e-filing system, so I don't know if it was emailed to the court directly or not. I can provide that now.
Okay, yes, I do not have.
And what's the email address, Judge?
Say again?
What is the email address? Because I know there's several Hathaways, so I don't know what to.
Right, do it Thomas.Hathaway at 3rdcc.org.
Copying Miss Maddox too, so she knows I'm not up to any funny business.
Okay.
Your Honor, for the Cobbs, did you want us to send the e-form signed by the defense attorney, or would you like to give your Cobbs on the record and then send the plea form afterwards?
Well, I would do the Cobbs on the record, then we do the e-form later, but that's why I was asking that Cobb's memos be sent beforehand so that I could email back my response to counsel and we could do it all at one time. But here, I don't see anything here. Take another look at a different file. But my first Copley file did not have a Cobb's memorandum file. Oh, here it is, the second. I do have it. I do have it. I'm going to print this up. And let's try to deal with this at 1 o'clock today when we get to that emergency docket.
Understood, Judge.
Okay.
Thank you. I appreciate it.
Very good. And Ms. Maddox, did you see a copy of that email? For the
Yes. Mr. Kearney sent me the Cobb's memorandum and everything on Thursday as well.
Okay, very good. Well, we'll do this. Kathy, would you check and see if we can get Copley on the ER docket this afternoon from the jail?
Oh, who do I call for?
Call him into the jail? Yeah, just see if we can do that, get him there. He's scheduled for today, but he's in custody and he's not on the ER docket.
Is he listed, did I list him as in custody?
Yes. Yeah, you got him here as in custody.
I see a J by his name too, so.
You see Jill? Yeah, that's right. So he's there. Yeah. Okay.
And that's Jill. Oh, do I know who? Did you call? Sorry, I don't.
Mr. Rather, which case are you here for?
Good morning, Judge. I received an email that a client of mine, who I believe was on a failure to appear warrant, was on the docket for today. I believe she was arraigned on the failure to appear last Thursday or Friday in front of Judge Ramsey. I'm not sure what the date would be for, to be honest. It's Shannon Johnson.
No, I see her on the docket for today. It's a violation hearing, but it says she's in custody. And again,
Yeah.
I don't on my emergency docket
I don't
D.
see her either.
Huh.
Okay, yeah, and I wasn't sure what exactly they gave this date for. She was arraigned on the failure to appear, and she has a final conference on the 17th in front. It's a Prentice Edwards case that you now have.
Your case, Judge.
Yeah, it's my case. So it's March 17th. She has a final conference in what?
In this courtroom, Your Honor?
Correct.
Oh,
I don't know why somebody set a violation hearing.
Yeah, I'm not sure at all either.
Not on probation, is she?
No, not to this court.
Somebody's.
oh, is it failure to appear?
It was a failure to appear, and she got arraigned on it last week. I think maybe one of the emergency dockets. I got something from Judge Ramsey's court.
All right, but it was a failure to appear for the final conference?
Correct.
Okay, so then the final conference was rescheduled for the 17th of March.
Yes.
Okay. Well,
Judge Ramsey said a $1,000 cash bond with a tether, so I guess it hasn't been posted.
oh. Yeah, that's what it is. She's still in custody because.
Oh,
she
right.
Okay. Or she could post the money, but she couldn't post a valid address for the tether.
Yeah.
Okay, well,
Who was that in the red, Judge?
that's Miss McLean. She's here for that Williams case, I think it was. Remember, she was here early, and she had. Oh no, you weren't here.
Oh.
No, she was here.
Williams
client-
case?
I'm sorry, Robinson, Javante Robinson.
Okay, I see the file. And I don't know what happened to Miss Coulter. We were just about to call her case. This is Javante Robinson. Miss McLean, are you ready?
Yes, I'm ready. Although I do think APA Maddox just sent me an email I'm trying to pull up regarding this.
Just let me know.
Okay.
And Mr. Quinn is here.
Okay, Mr. Quinn did call earlier.
Yep.
See what case he has.
Mr. Quinn, yeah, we should take him because he was here for sentencing, but his client wants it to be in person, so we're going to give him the day.
Okay, Judge, let me find out which case he has.
I'm sorry, that's Dismuke.
Oh, this
Marvin.
Okay. There it is. I don't know if I have the file. I did see a 19th file. Mr. Quinn? Parties on dispute? Dispute? Hi, Mr. Misick.
Good morning.
Are you on dispute?
I am the prosecutor on Dismuke.
Okay. Is Mr. Quinn on?
I see that he's on and he checked in earlier this morning and we've been emailing this morning. So I know that he's both aware of the event and around.
Okay. I was about to call the case, but I think I need him here. I don't have to.
Hello?
Oh, there he is.
Hi, Mr. Quinn.
All right. We're going to call the Dismuke matter.
All right, for the record, calling People versus Marvin Allen. 18-9049. Time scheduled for sentencing, appearances, please.
Good morning, Your Honor. Jonathan Mysick, P74620 on behalf of the people.
Mr. Classic, good morning to you.
Your Honor.
Mr. Quinn, are you there?
Yes. Good morning, Judge. Christopher Quinn, P69483, appearing on behalf of Mr. Dismuke, who is present.
All right. And Mr. Dismuke, please introduce yourself with your full name.
Good morning, Your Honor. My name is Marvin Allen Dismuke Sr.
And Mr. Dismuke, and good morning to you. Is your father alive, by the way?
Yes, he is.
All right, then we need to change that to a senior. I don't have it.
I changed it. The file's not gonna change, but I will change it.
Yeah. And Mr. Dismuke, do you consent to proceeding with this hearing with remote Zoom technology?
Yes, I do, Your Honor.
Right, very good. And, counsel, today is the date and time set for sentencing, but we don't have a pre-sentence investigation report. And Mr. Quinn, you indicated earlier today to my judicial assistant that your client wanted to be sentenced in person. Is that accurate?
Correct, Judge.
All right, well, we don't have in-person proceedings at this point. What I can do is give you a placeholder date of Wednesday, April 14th, and we will set that as a sentencing date. But again, it depends on what happens in terms of in-person court proceedings. Those are assigned by court administration. I don't assign those dates. They tell me when we can have a matter in this court. I assume we will be doing in-person sentencings by April, but it may or may not be the 14th, but that would be our placeholder date, if everybody understands that.
Understood, Judge. Should I call your assistant prior to the date to see if it's a go or just Zoom in?
That's right. What we need to do, we need to re-refer this matter for a sentence, a pre-sentence report. All right. So, Mr. Dismuke, I want you to take down this number.
Right.
You've got a piece of paper and a writing instrument there.
I got it.
All right. The number is 313-456-4600.
Okay.
Right. 456-4600. When you leave this Zoom court room, you call that number. That's probation services. Tell them that you're being re-referred for a new pre-sentence investigation report for an April 14th sentencing date. And they will give you the name and contact information of the person who will schedule that interview for you to update what was previously done. All right?
Okay, yes, sir.
All right. Did you have a previous interview for the pre-sentence report?
Did you get interviewed? Probation officer. Yes.
Yes. Okay. Well, this is going to be an update because when you did that, how long ago was that, by the way?
About a year ago.
Your Honor, the plea was taken on, I believe, March the 6th of 2020.
Right. That's why we need to update this. It's whatever they did was stale, but we don't have it. All right. Whatever happened, we don't have it. So we need a new one, and we're going to have it hopefully available to us before that April 14th date. And as soon as we can get you in for an in-person sentencing, we can take care of that. All right?
Understood, Judge.
Okay. Any questions?
Not at this time.
All right. Very good. See you all back here no later than the 14th of April then.
All right.
Your Honor, the people have one question.
Yes.
When last we were before Judge Edwards, his clerk sent defense counsel and I a sentencing readiness checklist form. Counsel and I filled out the form, and then I recently sent it to respective clerks last month, and then again this morning I sent another copy to your current judicial assistant. Is the court in receipt of that form?
Kathy? The Dismuke case. Is it Dismuke?
Yes, sir. Dismuke.
I thought we were doing a sentencing.
Yes.
Why do we need a trial readiness checklist for a sentence?
No, Your Honor, it's a sentencing readiness checklist form.
Oh, I hear what
I
you're
thought we
saying.
can't go forward with it though, because
What's that?
I thought we weren't going forward with this. We don't have a PSI, right?
No, we're rescheduling. He wants to know if the sentencing readiness checklist was received. She's checking right now.
Thank you.
All right. Yes, I heard her say yes. So we have that.
All right. Thank you very much, Your Honor.
Very good. And that was submitted to us and also to the court administration.
For administration.
Counsel,
I'm sorry.
who was it submitted to besides the court here?
Well, originally, Mr. Quinn and I resubmitted that to Judge Edwards' judicial assistant. And then once we realized that the matter was in front of Your Honor, I sent an additional copy to your clerk. So I don't know what, if anything, Judge Edwards' judicial assistant did with the form.
Okay, we will take care of this and submit this then. Very good. That's why I
right.
make sure, because if it's already been done, they don't want us to resubmit it. But we don't know if it was done, so we'll find out.
All right.
They didn't want duplicates is the point. All right. But we don't know. So one way or the other, we'll get this in. Okay. Thank you. I appreciate that, Mr. Maisel.
All right. Thank you, Your Honor. Thank you, Mr. Quinn.
All right, thank you.
All right.
Have a
All
good
right.
day.
Very good. Off the record on the dispute matter then.
Can
Thank
mute
you.
for a second?
What?
You
Oh,
just muted
yeah, I'm
me.
on the record. See if we can do some business then.
All right, parties on Robinson. Ready?
Good morning, ready.
All right, I'm calling the case right now. Calling case 20-497701FH, People versus Javante Robinson. This is the date and time scheduled for a final pretrial. Appearances, please.
Brittany Maddox on behalf of the people, P83204.
Good morning, Your Honor. Diana McClain, P54781, on behalf of the defendant Javante Robinson, who is also here on Zoom, waives his right for an in-person appearance on this and consents to Zoom.
Very good. And Mr. Robinson, please introduce yourself.
Javante John Robinson.
Mr. Robinson, good morning to you.
Good morning, sir.
All right. And is this a continued calendar conference?
I see the form was in there, that's why I called it like that.
Is this a continued calendar conference, correct?
Correct, Your Honor.
Yeah, that's what I thought. All right. And where do we stand?
Judge, it's my understanding that sister counsel needs an adjournment in order to get a crucial piece of evidence, if they have it.
And Ms. Maddox, that would be you, I assume. Is that?
Yes, Your Honor, that is correct. I spoke to my officer in charge and I got some of the evidence requested, discovery requested from defense counsel. However, I need to write a request to the MSP lab to get the other part.
All right. Well, once the evidence is in, where are we?
Well, defense counsel we have to get the data master printout sheet. I have the write-up from the arresting officers, but I need the ticket printout.
Okay, that's fine. But once we have that, what are we doing?
Well, Your Honor, I'm sorry, Your Honor, I didn't hear you. You went in and out.
Yeah. My question is, once that is produced, what are we doing? Are we going to trial or are we going to resolve it?
We're going to try to resolve it. If it doesn't exist, then we're still trying to resolve it. I don't believe it exists, but.
Ms. Maddox, is there an offer currently available to the defense?
There is an offer, Your Honor. The offer is for Mr. Robinson to plead guilty to count 1, carrying a concealed weapon, and count 2, operating with a high BAC. The people will dismiss count 3 and leave the sentence to the judge, to yourself, Your Honor.
All right. And what are the guidelines for those sentences?
The guidelines scored at 0 to 6 months, Your Honor.
All right. And taking a look at it, is you inclined to accept or reject that at this point?
Reject that, Your Honor, because of the OWI with a high bet. There's no proof of that. So.
Okay. Ms. Maddox, how soon before you're going to be able to confirm or?
And I'll call the MSP lab today to try to get the printout. Hopefully I could get it within the next week. I don't know how backed up they will be with sending it to me.
All right.
Well, Judge, I do want to let the court know that if it's received, because there have been so many reports by MSP regarding the data master analysis, and specifically those coming out of the Detroit Detention Center, that I would probably challenge that. So.
How will you challenge it?
Well, Your Honor, there are some documents that can be requested regarding the MSP data master analysis to determine if and when they had problems at the Detroit Detention Center and whether or not my client taking the data master at the detention center was one of the problems or during the time of the problem. I mean, it's been very well documented in the media by the Michigan State Police, the state, that there have been problems with these data masters.
All right. Well, so what I'm hearing is even if it does exist, you're going to be challenging it, correct?
Correct.
Right. Well, then I think we need to hold a calendar conference today.
Okay.
We can pick this one up. Sorry about that.
Oh, sure.
Yeah, I thought we were going to continue it, but given what they're saying, this is going to be a contested matter, so we need to get it on track. Yes, I'll tell you what, today is one for the calendar conference. And then the motions are going to be out by April 5th, and then quick dash, and then response by April 12th. And then motions that are timely filed will be heard on April 19th. Right.
Okay. No, 19.
I can have both the motion and the response, yeah, before we have the hearing. All right, I'm getting your dates right now.
Yeah, I know, that's why I wanted to see it.
All right, these are going to be the dates for the calendar conference. Please note these. Any motions that are going to be filed must be time-stamped and e-filed no later than April 5. Any and all responses are due no later than April 12. For all motions that are timely filed, they will be heard on April 19th. April 19th will also be the final conference in this matter. Again, 9 a.m. on April 19th. And we're not going to give you a trial date because it's obvious that those dates aren't being allowed by the court. It has to be set by court administration. So if we need to go to trial, we will get that at the final conference date. We'll determine that. But you must have a trial checklist readiness available and filled out for any matters that's going to be going to full trial. Understood?
Yes, Your Honor.
Your Honor.
Yes. Any questions?
No,
No, Your Honor.
I will tell the court that we do intend to resolve the CCW one way or the other before trial. This is just the issue of the BHC.
All right. All right. Very good. Well, thank you for that information. All right. And I take it, let's take a look here. What would be the estimated length of trial?
I would say no more than a day.
Okay. And the number of witnesses?
I'd say maybe 2 days, Your Honor, just depending on how, with the data master, if there's going to be any stipulations or if I have to call in evidence text to testify to everything.
All right. Well, we'll make that noted. Good. And the number of witnesses for the people?
Right now, it will be 3, but it's subject to change.
For the defense, how many witnesses?
Your Honor, no more than 2.
All right. And this is a jury trial?
Yes.
All right. And Ms. Maddox, you'll be representing the people at trial?
Who knows, Your Honor? I don't know. By the time this goes to trial, there will probably be a different prosecutor in this courtroom. So
Okay. But,
it will be to someone in the general trials division.
All right. But Ms. McLean, you will be representing your client at trial if it goes there, correct?
Correct, Your Honor.
All right. We want people that are going to be at trial counsel at that final conference then. All right.
Okay.
All right. Are there any motions for discovery that need to be heard?
I am now requesting, I did a discovery request a long time ago, but I am now requesting any and all analysis regarding data master apparatuses used by MSP and the Detroit Detention Center in or around June 2020 to August 2020.
Well, this happened in May.
Oh, well, May then. I'm sorry. I thought it was. Thank you for that.
You're welcome.
Okay.
Okay, if Mr. McLean can send that to me, that way when I contact MSP, I can make one request.
Yes, I will do that.
Okay. Anything further, counsel?
No, Your Honor.
No, Your Honor.
All right. Then, Mr. Robinson, we'll see you back here no later than April 19th for that final conference. All right?
Your Honor.
Very off the record on the Javante Robinson matter.
Your Honor, pardon the interruption. Has the court heard from either Bryce Dooley, the defendant, or Ed Taylor, his attorney?
Have we heard from Mr. Taylor yet? Did he respond to anything? We've not heard anything back from either one.
Understood.
Are you able to get a hold of Mr. Taylor? Yes,
I'll attempt to do so.
Coulter's. I think she's ready. record, calling People versus William Johnson. This is case 20-187101FH. The matter before the court is an arraignment on the information. Appearances, please.
Brittany Maddox on behalf of the people, P83204.
Good morning, Your Honor. Jennifer Colthurst, P52876, appearing on behalf of Mr. William Johnson.
Good morning, and Mr. Johnson, please introduce
Good morning,
yourself.
sir. William Johnson.
That's
Good morning.
William Clarence.
Yes, sir.
Right. And good morning, Mr. Johnson.
Good morning.
All right, and we're proceeding with your hearing today with Zoom technology. Do you consent?
Yes, sir.
All right. And Ms. Colthurst, what are we doing with your client today?
Well, Your Honor, my client, I believe he needs to be refreshed as regards to the offer. And
the arraignment first.
oh, I thought he's been arraigned already, but if not, Your Honor, we will waive the formal reading of the felony information and stand mute.
And Mr. Johnson, your attorney stands you mute and waive the formal reading of the felony information charge. I'll enter a not guilty plea for you on this matter. That places your case down on the Third Circuit Court felony docket. And Ms. Maddox, you've heard Ms. Colthurst looking for a requested plea offer.
Yes, Your Honor. The offer is for Mr. Johnson to plead guilty to an attempt possession of a controlled substance less than 25 grams. The people will dismiss the habitual offender fourth offense notice and leave the sentencing to the court. Its guidelines are 0 to 22. With the habitual, I will have to check the book to see what they are without the habitual.
With the habitual, is that correct?
0 to 22 with the habitual, but we will dismiss the habitual, so it'll be 0 to 11.
Okay. Yeah, I think maybe we should do that. All right. So Ms. Colthurst, you're going to take some time to discuss that with your client?
Yes, I will, Your Honor. I do have to return on March 22nd for another matter. Is it possible to set this matter on that same date?
Yes, we can do March 22nd for a calendar conference.
Thank you.
All right, well, I'll have to get another, I'll blank the form then. I thought we were doing.
Okay. No, that's okay. We will do that. So in the meantime, bond will continue. And anything further?
Mr. Johnson, is there anything else I may have missed?
No, ma'am. No.
Okay.
Right. I would give this injunction to the attorneys. If this is a matter that's going to be settled with a plea at that calendar conference date of March 22nd, make sure you have all your plea papers executed and returned to the court before that. All right, before that date.
Yes, Your Honor. Ms. Colthurst, you have the plea form. If your client wants to take it, just send it back before and I can send it to the court.
Certainly. I am in receipt of the plea form, and thank you for emailing it today or previously. Thank you.
Off the record on the William Johnson matter then. All right.
Thank you. Have a good day, Your Honor and staff.
All right, thank you. Mr. Johnson, you'll zoom back to this courtroom on March 22nd then.
No problem.
All right, very good. Thank you all.
Thank you. Bye-bye.
Thank you.
Judge, off the record, are we going to lunch? Before, because we got to come back.
I have yet to go to lunch in 3 years here.
Ah.
My AOI goes to 2:30. And we had to finish up because my deputies came at 5:30 and they had to leave by 3:30. So they had to make sure all the defendants were back in
Your Honor, this is Brittany Maddox. I still have Derek Keys and the two Shane Caroline matters up today, but I don't see either defense attorney or defendant. I'm sorry, I think you might be muted. Can't hear.
Oh, thank you. Ms. Turchan, can you hear me?
Yes, I can hear you now. Yes.
There we go. All right, thank you.
Shane Caroline?
We have Shane Halliday and a couple of other violators scheduled for today.
Hold on for a second. He thought it was at 1.
Yes, we have 7, I believe, in all, but they're all for the afternoon because they're all in custody.
Yeah, he is in custody.
Is Shane Halliday in custody?
Well, Shane Caroline's in custody. I'm talking to Mr. Callahan now. They thought it was at 1.
Well, we can do it at 1. I can see why, but again, they're not listed.
Yeah, they're not listed in custody, but not if we can't get him though. The jail's hasn't brought him over. I mean, are you sure he's in jail? I don't see a J. Because it's a 50,000, 10% fine. Okay. He said he just went to the jail and saw him, so he's in jail, but we don't show him being in custody.
Wow.
Okay, Mr. Callahan, try back at 1. Hopefully they'll bring him home. Docket D.
D is in David.
Yeah, as in David. Jennifer Woodard, she's scheduled for this afternoon at 1 o'clock too. She's scheduled for the 1 o'clock docket. I got them. They're both on the docket. One is the AOI and the other is a violation of probation. And one for drugs. Somebody made a mistake and scheduled it for violation of probation. It's an AO, 2 AOIs. 2 AOIs. Gotcha. No, it's 2 AOIs.
So Shane Halliday is this afternoon.
I'll see you later. Okay. He said he'll be here at 1.
Okay. And we got to get a hold of the jail to try to get the Caroline on.
Oh.
But the jail has already indicated Copley and Davis cannot come.
Well, Woodard is going to be here. Woodward's already on the docket. That's Mr. Callahan's case.
Okay.
But I don't contact the jail. Usually that's done by the law clerk. So I don't know, and I don't think they're going to bring anybody extra.
Well, that's why I just said that Kathy tried to get Copley and Davis on, but they said that it needs to be adjourned because they don't have enough cameras, as I quote Division 2. So,
Okay.
but what about Dooley and Mr. Taylor?
Dooley. I
Defendant
haven't
Dooley?
talked to him yet. Let me call him. I don't see. I have a Bullock on the docket too. I haven't seen anybody for that.
Your Honor, I attempted to call Ed Taylor on Dooley, and the number that is in the bar journal goes straight to voicemail.
Oh, really?
Wow.
Let me see what I have.
And Bullock is probably this afternoon. It looks like he's in jail.
Yeah, because he has a bond report here, which you probably have, I don't know if you've seen this or not, Judge.
Nope.
Bond report for Bullock, he should be,
Well, this is interesting. He's in jail too.
he is, and he's not on the
He's not
emergency
on the
docket.
docket.
All right, let me try Mr. Taylor. I'm probably gonna get the same response.
And Your Honor, this is Tim Rather again. Agent Tershon, in her wisdom, let me know that Shannon Johnson is most likely a tether violation because she was on tether to Judge Prentice Edwards. I don't know if there's a report for that.
We have the Johnson file.
Mr. Taylor, we're looking for you in Judge Thomas Hathaway's courtroom for Bryce Dooley. It's not at 12 o'clock p.m.
Well, Mr. Rather, we were talking about moving that Shannon Johnson matter to March 17th.
Oh, right. And that's fine with me. I just wanted to make sure that we were all on the same page before I left. I was going to wait and just to make sure. And I can wait if you need me to.
Okay,
Judge,
no,
what was that you were asking me? I was on the phone with Mr. Taylor, he's about to zoom in now.
Okay. Was that Taylor with Dooley?
With Dooley, right. March 17th. Did you say March 17th for Johnson, Judge?
Yes. Yeah, that's the final state, I believe, in that case.
Your Honor, can I have a copy of the tether violation sent to me?
If you have it, that would be wonderful. We don't.
I don't have it. I thought the court had it. I didn't.
Nobody does.
Okay. I guess I'm kind of concerned. I don't know, if it's a regular violation or if she violated the no contact, which will be concerning.
It looks like she went before a court on 2/24 and got a bond.
She did. She went in front of Judge Ramsey, got a $1,000 bond.
With a tether.
Correct.
But he doesn't believe she's been able to post $1,000.
She hasn't been able to yet. I'll be in I have contact information for her family and I'll set up a visit with her to see what I can get done with that.
All right. But I think at this point, what we have is a March 17th final conference. So
Correct. Okay. Thank you.
yeah, I think we'll delete this from the docket for today because they're not bringing her in.
Yeah, I didn't figure. Thank you so much. I'll let you know if anything else comes up.
Please do, Mr. Rather. I appreciate that. And thank you for
No
being
problem.
proactive.
Thank you.
Wait, hold on. Who said they were bringing her in? Shannon Johnson, is that who you're talking
Yeah.
about? No, I never said that. She's on the docket.
No, she's not.
She was let's see, and I'm from Friday, so she's on our docket, but she's on.
Well, I know she's on the docket, but she's in jail.
I know, so she's coming at 1.
But she's not on the ER docket.
I know that, but she is. I've already checked with the jail. The only two they couldn't give me were the
Mr.
two.
Rather, check that. Apparently,
That's fine.
apparently your client is going to be showing up
Okay.
At 1 o'clock.
on 1 o'clock. Okay, that's the first we learned of that.
No, the only.
Is it the same Zoom or is it through one of the emergency dockets?
It'll be the ER docket. Yes,
Okay.
D is David.
D. Perfect. I'll be there.
The only two that couldn't come, that they couldn't produce were individual 2.
Okay, so,
The other add-on was fine.
okay, but, well, we got a couple others then. Is Caroline coming too then?
I have to look at the docket. I don't know what I wrote on it.
Shane, Caroline.
Yeah, do you have the docket? Is she on the ER docket?
Oh, there's
She's
the
not
ER
on the
docket.
ER
That's
docket.
what I have. On my notes.
Yeah. We have a number of people that are on different that was docket that incarcerated
I
that
only
weren't
have
on the PR docket.
four.
What's that?
4 people.
That's 4 from this docket, yeah. We got Johnson.
And
Copley.
Copley has 2 cases, so that's 2.
Copley, Davis,
They're not
Johnson,
coming.
Caroline, Robinson.
You know what, I didn't see Caroline, so just forget Caroline, but Johnson, I confirmed is ready and coming.
Okay. Yeah, because Caroline has 2
Caroline,
cases.
I'm not sure what's going on, I'll find out.
Let's see if Caroline is coming.
Is Mr. Taylor still there for Dooley?
And then Kathy? Kathy? Mr. Thompson, who are you here for?
Good morning, Your Honor. I'm here for James Pavlich it's an expungement. And I apologize, we sat for 2 hours waiting with Judge Edwards. We were told by another clerk that it was Judge Edwards, and then discovered it's on the docket for Your Honor.
It's Pavlich, James William Pavlovich, is that it?
That's correct.
Okay. Do we have that file?
We don't, Judge.
No. We don't have that file. Ms. Maddox, are you still there?
For 14.
I'm here.
Okay.
It's probably in Judge Edwards' courtroom. Unless this was something that you already had on your docket.
No, this is Judge Edwards' case, but it's in this courtroom, but we don't have the file.
No, we do not.
And Ms. Maddox, the question I was, do you have any of the post-conviction files with the general's responses?
I have none of them, Your Honor, which is why I wanted to come look at the court files. I don't have any of like the attorney generals or the MSP liens or anything.
And Mr. Thompson, that's the problem. We don't have any files here. You're not the only post-conviction matter set for today, but court
I can
administrator
appreciate that, Your
set the
Honor.
case for today, but didn't provide the files for today.
I can definitely appreciate that, and what's going on with COVID and Zoom is understandable. I don't know if it helps, Your Honor. I do have my client's criminal record in front of me that consists of one other thing. As an officer of the court, I can, tell the court that is correct.
Is your client here?
My client is here. My client drove about an hour up from Ohio for this hearing, and I believe this was filed last June. I don't know if the court would entertain this, but I would be happy to make a record if the court would take something like this under advisement after seeing the file. I don't know if that's something that's done, but.
We can't hear you.
Oh, I'm sorry.
Any objections, Ms. Maddox?
I'm sorry.
I don't think she heard me, Judge. I would be happy to make a record if the court would be able to take this under advisement and make a ruling.
We can do that. However, I can't proceed until I see the packet, the application, the attorney general statement. But if we want to do if your client is here, if the judge wants to hear from him, and then when we get the paper part of it, maybe continue without him. I don't know if the court wants to do that.
So you have no objections is the answer then?
Right.
Okay. Yes, we can proceed then, and we'll hopefully marry up the application with the file. and get
I
you-
appreciate that, Your Honor. And I do have a, I'll check my file. I can send over information as well. I do have a statement from, I don't know if it's the Attorney General or the police, the state police, indicating that he's eligible.
That's
This
what
is
we're
from,
looking.
oh, it's the Attorney General. I do have a statement here. Review of the application criminal history shows he may be eligible to have his conviction set aside. And this is from John Pallas, Assistant Attorney General from the state of Michigan. I could forward this to the court.
That'd be, please do that.
Right, 'cause I didn't know what date that this was filed or anything. It says it was placed in 602's mailbox on January 20th. So that's
January
where it was
20th?
sent here. That it was sent here
What
in
was?
this, to this court.
Okay,
What was?
good.
The expungement file for Lovich.
Oh, do they? I don't know if they put them somewhere else, maybe.
I don't know either.
Shannon Johnson is gonna go. Anybody who's in custody and who's in Division 2 will still go. Division 2 was the problem.
Okay, so Division 2, none of them will go. Right. Very good, thank you.
You're welcome. What's the name on the expungement?
Lovich.
Lovich.
Thank you.
It was sent to this court on January 20th.
When it was said, sent to the courtroom, you mean Judge Prentice Edwards' courtroom. So he's got that, he ported that right downstairs, so we don't have it. See, my courtroom, but no, that's amazing. Hold on, let me just double check.
I thought you guys switched out everything.
That's what I'm looking at. here.
Do anyone know if Kevin Jones has been seen?
We might have it.
What email address should I send this to the court?
Send it to Kathleen with the C dot Belcher, DELCHER at 3rdcc.org.
I'll have this to the court in about 2 minutes.
Thank you. All of my old court emails.
Mr. Thompson, can you also send it to me? I put my email in the chat.
Oh, thank you. Absolutely.
Yeah, it's amazing. And starting February 5th, I started getting information for this court. But prior to that, everything that I've got there is my old document.
So I found the expungement file drawer, but it's not in there. And if they would have got, I heard somebody say something about January something, they had it.
January 20th.
That would have been before we came here.
Right.
Oh, yeah.
So it should be in there, and it's not.
Okay,
They do have 3 expungement files, but that's not one of them.
okay. He's sending you the information right now.
Okay,
But in the meantime, let's see if we can't conduct some other business. Mr. Taylor? Mr. Taylor?
Yes, Your Honor.
All right. We were looking for your client, Mr. Bryce Dooley.
He should be on.
Is that him?
Bryce's phone. All right, there he
Yes,
is.
ma'am.
Very good. Excellent.
All right. For the record, calling People versus Bryce Justin Dooley, case 20-162301FH. This matter before the court What is this, a calendar?
Calendar conference.
A calendar, is a calendar conference, attorneys appearances, please.
Good morning, Your Honor. Alexander Tronahachi on behalf of the people, P81844.
Mr. Gronchik, good morning to you.
Good morning, Your Honor. Edward Taylor, P57166, appearing on behalf of Mr. Dooley.
And good morning, Mr. Taylor. And Mr. Dooley, please introduce yourself, full name.
Good morning, Your Honor. My name is Bryce Dooley.
That's Bryce Justin Dooley.
Bryce Justin Dooley, yes, sir.
Yes, and good morning to you. And we're conducting this hearing with Zoom technology. Do you consent?
Yes, sir, I do.
All right. And we're here today for a calendar. It looks like it's calendar conference. Is that true? This has been around a while.
Your Honor, if I may.
Yes.
So the offer that I've had in my file for quite some time is to plead as charged in this case with a sentence agreement to 3 years probation, the first 12 months in Wayne County Jail with early release upon completion of the DVT program, no contact with the complaining witness, and substance abuse evaluation with treatment if recommended. And in exchange, we would dismiss the defendant's second file. For speaking with my supervisor, it's my understanding this is the best and final offer. I would ask for a short adjournment so that Mr. Taylor can consider it one more time with his client. And then after this final adjournment, we're either taking the offer or setting this for trial.
All right. Mr. Taylor.
Your Honor, the sister case is set for an exam July the 27th. And my client.
July 7th of 2021?
That is correct. And my client indicates that he's innocent of these charges and he wants to have his day in court, Your Honor.
So innocent of the charges in this case, is that correct?
Well, actually, both cases, Your Honor.
Right, but this case is the one I have, all right?
Yes, correct.
Yeah, the other case, if it's going to be coming in another 4 months, that's down the road. Okay, so what you're saying is that you're rejecting any offers of settlement, correct?
That is correct, Your Honor.
All right. Let's take a look here. We'll do this as a calendar conference. All right.
I didn't know if you were on adjourn or not.
No, we're gonna take we'll do this as a calendar conference. And we're conducting the calendar conference today, March 1st. Are there any motions that are anticipated to be filed here?
No, Your Honor.
No, Your Honor.
All right. If there were to be any, they were to be filed no later than April 5th with responses by April 12th. And we will hold the final conference on April 17th. And April 17th would also be the date for any motion hearings. So we'll have the final conference on April 17th at 9 a.m. Is there any discovery outstanding?
I don't believe so, Your Honor, but I will double check with my OIC, and if there is, I will have it to Mr. Taylor before the 17th.
All right, Mr. Taylor, is there any request outstanding for discovery currently by you?
I believe I have all the paper. If it's any digital, Your Honor, I would appreciate that.
All right. And what is the estimated length of trial?
I believe I have 3 to 5 witnesses, so I would assume 2 days.
Mr. Taylor, agreed?
Yes, Your Honor.
And how many witnesses for the defense?
2, Your Honor.
All right. Yep, 5 to 7 witnesses, that 2 days, 2 to 3, okay. And jury trial or waiver?
I'm open to both.
Jury, Your Honor.
Jury trial, very good.
There are no interpreters on behalf of the people, and there's nobody traveling out of state?
No.
Okay. Let the make sure we have a good record. All right. And I take it that the defense is not interested in any other plea offers. Is that correct?
That's correct, Your Honor.
Right. Then the offers are to be conveyed as of today's date. That's 3/1. And the response due by today's date, 3/1. So there will be more offers, and we will. I cannot give you a trial date because, as everybody knows, we are running limited in-person jury trials here at the current time. So as soon as you submit your jury trial readiness checklist, we will submit that, put you in line to be selected for a trial. But you must fill out that jury trial readiness checklist, and the revised checklist came out February 22nd. Do both counsel have access to that revised checklist?
Yes, Your Honor.
I don't believe I do, Your Honor, but I'll check.
Right. Well, you need to have that. It needs to be done and then submitted. As soon as you do it, submit that. And it states here that once the jury trial readiness checklist is submitted, that's it. It's going to go into trial. No settlement offers can be proposed or accepted. We have limited capabilities, and once a case is selected for that trial date, that's it. All right. And if there's any emergency motions to adjourn it within 30 days of the scheduled trial date, the presiding judge is the one who has to grant that. This court cannot. And I don't think he's been granting many of those. So,
Your Honor, I will also file my proposed jury instructions for the charges and my witness list before the 17th.
Yes, and Mr. Edwards, you need to get those in also.
Very well, Your Honor.
Okay, very good. So we'll see you all back here then for the final conference. This case, hopefully, is going to be ready to go for trial probably in the next 3 or 4 months.
Understood.
Okay.
Thank you, Your Honor.
Very good. Anything further?
That's April 17th, Your Honor.
Right, April 17th, 9 o'clock is our final conference. And at that point, I'm going to make sure that you have submitted everything you need to do, that jury trial readiness checklist, your witness list, your jury instructions, anything like that.
Very well. Thank you, Your Honor.
It's Saturday.
Oh, hold on. It's April 19th.
April 19th.
I'm sorry, I said April 7th. It's April 19th, not the 7th.
Okay. All right, thank you.
That I gave you a Saturday date, and that's not going to happen.
I was trying to get lucky here.
There you go. Okay, April 19th. My apologies on that, counsel.
No problem. All right, thank you.
All right, very good. Okay. Do we have anybody else ready to go?
There's Mr. Schlaf.
Mr. Schlaf, you got Shane Holiday. That's for this afternoon. You're muted.
Here I am.
Yes.
We have Derek Keys this morning.
Say again?
Derek Keys this morning.
Is that Derek Keys?
He's there.
Here, yep.
Okay.
Mr. Keys is there. Good.
All right, for the record, what is this? Is this a calendar conference?
Calendar conference.
Okay. All right, we're on the record with the matter of People versus Derek Keys. This is case 2121401 FC. This matter before the court is a calendar conference. Attorney, appearances, please.
Brittany Maddox on behalf of the people, PA 3204.
Good morning.
And good afternoon, actually. James
Great.
Schlaf on behalf of Mr. Keys.
All right, good afternoon, Mr. Keys. Please introduce yourself.
Mr. Keys, this is your time to shine. He's not very knowledgeable about Zoom. Mr. Keys, do you hear us? Would you at least nod?
He's got audio, but he doesn't have video.
I see him.
I see him too, but as I'm looking here, he's got his audio. He can see us, we can see him, but he does not seem to have audio.
Mr. Keys, there should be a microphone there on your box, on your device. Just touch it to get the slash off of it.
He can't hear us because I don't know why he can't hear us.
Mr. Keys, can you hear us? Wave to us if you can hear us. Wave again.
I don't think his audio is connected.
No, that's what I'm saying. It is not.
Can you hear us, Mr. Keys? I don't think he can hear us.
No.
I just have to text him.
Well, this is what I suggest. We're just at the calendar conference. Let's get some dates, and I will speak to him afterwards, explaining everything and try to remedy whatever's wrong with his device.
All right, and you consent to this Zoom hearing today, despite the fact that your client can see us but cannot apparently communicate.
Yes, we spoke about this case a lot. He knows what we're doing.
All right, very good. Thank you. And are any motions expected?
Have we ordered the transcript yet?
I have a transcript.
You say you do?
Mm-hmm. Yes.
Yeah, I do. I just haven't gone to get the file. I'm sorry. It's been that morning. So I'll review the transcript. Perhaps there will be.
If the transcript is in the Odyssey.
I'll take a look. I'll take a look for it.
Okay. Well, then what we're going to do is this. Any motions that are going to be filed must be filed no later than April 5th. All responses filed by April 12th. And for all motions that are timely filed, they will be heard on April 15th.
I'm sorry, I didn't hear that last date, Judge.
April 19th.
Okay.
19. And Monday, April 19 will also be the date for the final conference. I can't give you a trial date because we don't yet know when we're going to be resuming in-person trials to the extent that we can start scheduling them ourselves. As we all know, it's being done by a group that assesses the cases for priority. What's the estimated length of trial if this is to go to trial?
I think it should be a very quick trial, 2 days at the most.
2 days.
And number of people for the number of witnesses for the people?
Your Honor, I have about maybe 3 or 4.
And for the defense?
One other than my client, I believe.
Okay. And jury or waiver?
At this point, it's a jury.
All right. And are there any other pending cases?
No, Judge. This is his first felony ever.
Okay. So both of you are going to be trial counsel then? Pending.
I am, yes.
Yes.
All right. And that means both of you must be present for that April 19th final conference date. And is this a case likely to go to trial?
I believe so. I'll talk to the prosecution again about reviewing their offer, but as of now, for sure.
All right. Well, let's put in here that any plea offers to be conveyed to the defendant must be conveyed by April 12th. Any final additional ones by April 12th. And that would give us a week before the April 19th a final conference date to see if that is going to resolve this matter. If not, on April 19th at the final conference, we'll determine whether or not a jury trial readiness checklist needs to be immediately promptly filled out. Also, witness list must be, filed, jury instructions, all of those things must be taken care of. Any questions?
No, Your Honor.
No, Your Honor.
All right, very good. There's nothing further then. We will see you back here no later than April 19th, 9 o'clock.
A quick question on another matter, if I may, Judge.
Yes.
You mentioned Shane Holiday. That was not on the docket as posted for the emergency docket. Is it still on for today?
That's what I'm told. Yes, that's what I'm told. We have a number of cases that weren't on that emergency docket today. So we're adding them to it. I think we've got 3 or 4 more that we're adding, but in that group is Mr. Holiday.
One of the things is that I was supposed to get it. Remember, I was supposed to consult with Judge Edwards about that issue I had about which court my client belongs in.
Yes.
I haven't received any word from Judge Edwards yet. So I'm not quite sure we're going to be getting anything out of Mr. Holiday today, other than just picking up your time.
Right. Okay.
And I talked to Mr. Makepeace about it. I don't think he's, if we adjourn it, he'll have any problems.
Okay. All right. Very good. But you'll be back then about 1 o'clock or so.
Okay.
All right. Very good. And I don't know when your client, Mr. Holiday, is going to be brought out because he's an add-on to the jail also.
I understand.
It's the way the world is these days. So all we do is learn how to practice patience, right?
All right, then. Thank you very much, Judge. Miss Maddox.
Very good.
Mr. Keys, if you can hear me, log off and I'll call you. He might be on for the rest of the day.
Might, or just send him a chat, put it in the chat.
I don't know if he knows from chats.
Yeah.
Your Honor, I'm ready on the Povich expungement.
Yes. Okay. Let me brought me that documentation. Let me see if it's here. Oh my God. Yeah. Oh. Okay. Okay. They said that they were ready.
I'm trying to help him. I don't think he can see it.
Whatever.
Oh, there's one in the jury. Oh, okay.
Oh, great. Thank you.
ready?
Okay, we can call Pavlovich.
All right, we're on the record with the matter of People versus James Pavlovich. This is case 14-349-501FH. This matter is a post-conviction motion for expungement. Appearances, please.
Brittany Maddox on behalf of the people, P83204.
Good afternoon.
Good afternoon, Your Honor. Kenneth Thompson appearing on behalf of James Pavlovich, who is present to my right. Your Honor, we do consent for this to be live streamed on YouTube.
Good afternoon, Your Honor.
And Mr. Pavlovich, please introduce yourself with your full name.
My name is James William Pavlovich.
Very good. And are we ready to proceed with this application for post-conviction expungement?
We are, Your Honor.
We are, Your Honor.
Then, Mr. Thompson, this is your motion and application. You may proceed.
Thank you, Your Honor, and thank you to the court for considering this with the difficulties this morning. Your Honor, my client's a 53-year-old male, hard worker, works currently 84 hours a week in his job on a week-on, week-off basis. This matter happened over 7 years ago. I think it's worthy of explaining his record a little to the court. 10 years ago, he went through a very difficult divorce, Your Honor. And a situation occurred, this will be the first misdemeanor you see on his criminal record, occurred where a pillow was thrown and the police were called, and my client, when his license was handed back to him, it pulled the license back as it was handed to him. And, you know, it probably not the most pleasant matter. He was subsequently charged with resisting. He incurred quite a beating that day from the officers. I believe that's why the other charges were dropped, other than the misdemeanor obstructing. His CPL was revoked at that time due to the domestic violence and wasn't renewed. He never tried to get it back. And the underlying case before the court is a attempted CCW where he was driving in Livonia and had his gun in the back seat away from reach. He did plead to an attempted CCW. Your Honor, my client's a good guy. Other than this, he has no criminal record. He's never been before the court. He's a hard worker. He has a 25-year-old son. He currently lives in Ohio. And, you know, I would ask the court consider, you know, taking this off his record as an expungement. He is gainfully employed and would want to consider different employment in the future that this could hinder.
All right.
Nothing
Mr.
further.
Thompson, I see that he was sentenced to 140 days in jail for that attempt CCW, but to be released upon payment of $900 in costs. How much time did your client actually serve?
You served
21 days.
21 days, Your Honor.
All right. Very good. And Ms. Maddox, on behalf of the people?
Your Honor, at this time, I reviewed the application and the prosecutor's office and the Attorney General have no objections to setting aside the conviction.
All right. Well, Mr. Pavlovich, why don't you tell me why you believe you deserve an expungement?
Your Honor, it's been like it's been 7 years, and I just want to put this behind me. I believe that I'm a good citizen. I've made a lot of changes in my life. I have a good job, and I would just like to put all this behind me.
All right, and you've had no contact with the criminal administration of justice since the last misdemeanor conviction?
Correct, Your Honor. I haven't.
Are you currently employed?
Yes, Your Honor.
Well, based upon the information that I have available to me, I can state and find on the record that the Michigan State Police have reported the required information from its records to this court, which I have reviewed. The applicant has not been convicted of more than one felony and 2 misdemeanors as defined in the statute and Michigan Compile Law 780.621. And the convictions that he does have are not for offenses found listed in MCL 780.6213 as convictions that may not be set aside. It has been at least 5 years since the sentence was imposed and since he was discharged. And an opportunity has been given to both the Attorney General's office and the Wayne County Prosecutor's office to contest the application. Neither office has done so. And the circumstances and behavior of the applicant as set forth and made known to the court on this record do justify setting aside the conviction, and I do find it is consistent with the public welfare. It is therefore ordered that the convictions listed in this case, attempt carrying a concealed weapon, is set aside, and the arresting agency and the Michigan State Police shall maintain a non-public record of the order setting aside the conviction and of the arrest and fingerprints, conviction, and sentence in this case. I've just entered this order, and we will have it entered into the Odyssey system. You will get a copy of it. And I congratulate you, sir, and trust that going forward, you'll continue to lead a crime-free, productive, wholesome life.
Thank you so much, Your Honor. Thank you.
Very good. Congratulations to you.
Thank you.
Thank you, Your Honor.
Thank you. And Mr. Thompson, thank you. Good work on behalf of your client.
Thank you. And thank you to the people.
Thank you. If there's nothing
You're
further
welcome.
on the James William Pavlovich case, thank you.
Okay, lunch break.
I think so. We've got Derek Moore, but we don't have anybody here for that. It's a review date. Not sure what that is. But I think that's it. No one else is ready to go.
Okay.
All right. See you back here about 1 o'clock then, Miss Maddox.
Yes.